2024 at 10 a.m. I believe all parties participating in this matter are available and the docket is in order. Thank you, Madam Chair.
Thank you, Mr. Winburn. We do have some participants today. Let's take appearances. Who's here for the South Carolina Telephone Coalition?
It's on.
It's on.
Oh, okay. Good morning, Madam Chair and Commissioners. I'm Peg Fox. I'm here this morning on behalf of the South Carolina Telephone Coalition.
Thank you and welcome. And who's representing the South Carolina Television Association?
Good morning, Madam Chair, Commissioners. My name is Andrew D'Antoni, and I'll be representing the South Carolina Cable Television Association.
Good morning and welcome to you, Mr. D'Antoni, and the Office of Regulatory Staff.
Thank you, Madam Chair, members of the Commission. I'm Ben Mustian. With me today is Clayton Vaughn. He is our telecommunications specialist and hopefully will keep me straight today.
Thank you, Mr. Mustian. Welcome to you, too. Ms. Boyd.
Yes, good morning, Madam Chair, members of the Commission. The Commission staff is continuing to ask the Commission to consider its regulations, which are the results of the Commission's 5-year review under Title I, Chapter 23, Section 120J. And today we are asking the Commission to review the proposed regulations related to amending the Telecommunications Utilities Article 6 regulations. Before I begin the presentation, Madam Chair, regarding the proposed changes, I'd like to ask you to make certain jurisdictional documents a part of the record for today.
If you'll identify those and
yes,
let's
ma'am.
go with those.
So the first document that Ms. Elise Wilson is going to distribute to you is the transmittal form for the notice of drafting, which was filed with the Legislative Council on May 12th, and the actual notice of drafting. If you would, Madam Chair, consider marking that as Exhibit Number 1 and entering it into the record of today's proceeding.
Any objection? Hearing none, the document transmittal form and the accompanying notice of drafting will be marked for identification as hearing Exhibit Number 1 and received into the evidence of the case.
You okay? We would ask, Madam Chair, that document number 2 be marked for identification and entered into the record. This, Ms. Elise Wilson will...
Let me ask you, go ahead and
Sure.
hand the parties first so they
Okay.
can be looking at it to make sure so when I ask if there's no objection, if you hand it to the parties first, they need to look at it. Thank you. Sorry.
Yes, ma'am. The transmittal form for the proposed regulation, it was filed with the Legislative Council on November 9th, and the proposed regulation is attached.
Any objection? Hearing none, the transmittal form and the proposed regulation will be marked as hearing Exhibit Number 2 and received into the evidence of this case.
The third document, Chair Bell, sir, contains the verification of the struck-through version and the clean version of the proposed regulation, and I'd ask that that one be marked for identification and entered into the record as the next hearing exhibit, number 3.
Any objection? Hearing none, The,
Madam Chair, could I just ask a quick question?
Mr. Mustian?
So, I think the last one, there's two sets. There's one that's 19 pages and then one that's 16 pages. Is there, I should know this, I'm sure, but is there a difference between the two, obviously?
Yes, so the first set, you'll notice when you flip through, Mr. Mustian, that there's some language that's struck or underlined.
Okay.
And then the second set should not contain, it should be, it's viewed, it does not contain any stricken or underlined language. So
Got it.
okay.
All right. Sorry, thank you.
Madam
So
Chair.
basically, the first one is the red line and the second one is the clean version?
Yes, ma'am.
Okay. Commissioner Thomas?
I think I'm looking at the same document as Mr. Mustian, and it appears to me that it is even number pages, but I don't see odd number pages. Maybe I'm wrong.
It may be the copy you were provided. Wait a minute, are you talking about number 2 or are you talking about the current one? He is correct. That's only odd number of pages. With regard to what the executive director has asked to be marked as hearing exhibit 3, is there any objection? Hearing none, the verification of the proposed regulation with the red line version and the clean version will be marked for as hearing exhibit number 3 and received into the evidence of this case.
Okay, Madam Chair, if you give me a second, let me distribute what will be 4. Madam Chair, I'd ask that hearing exhibit 4, which is the draft notice that was published in the State Register on May 26, 2023, be marked for identification as hearing exhibit number 4 and entered into the evidence of this case.
Any objection? Hearing none, the notice of drafting published in the State Register on May 26, 2023 will be marked for identification as hearing exhibit number 4 and received into the evidence of this case.
Okay, Madam Chair, the last document that's been distributed contains the proposed regulation that was published in the State Register on November 24th, 2023. And there's a second document that is the actual proposed regulation that contains the stricken and underlined language that is the information that is included in the link in the proposed, at the end of the proposed regulation. So it's the actual body substance of document number 5267.
Parties, any objection? Or participants, I'm not sure what we call everybody, but any objection? Hearing none, the proposed regulation document that was published in the State Register on November 24, 2023, and then the text of the proposed regulation that is available through the link in the State Register will be a composite exhibit marked for identification as hearing exhibit number 5 and received into the record of this case.
Madam Chair, if you're okay with me proceeding, I think that everyone can still view what was officially published in the State Register, the last document that I provided. So if you're ready for me to proceed with the slide deck.
Yes, ma'am. That's all our jurisdictional documents?
That concludes our jurisdictional documents. Yes, ma'am.
Thank you, ma'am. Please go ahead.
Okay. Thank you, Ms. Purvis. So, Madam Chair, as I mentioned earlier, today's hearing relates to the continuous review of the Commission's regulations pursuant to South Carolina Code annotated section 1-23-120J. And the next slide contains information that I previously stated, the publication date of the notice of drafting in the State Register and information regarding the proposed regulation published in the State Register on November 24th. The next slide contains a list of the regulations that were impacted by the filing of these proposed regulations for Article 6 with the Legislative Council. And the first regulation for your consideration is Regulation 103-612, data to be filed with the Commission and provided to the ORS. If you're looking on page 5 of the document that was actually published with the proposed regulation in the State Register, I'm on page 5, and you'll see first where number 2.2.1 is struck. There isn't any substantive language relating to that section, so that number's been struck. Then under 2.4, authorized telephone utility representative, staff proposes adding the utilities representative's email address to the authorized utility rep form. In addition, the authorized utility representative form will contain, over on the top of page 6, additional information, including the regulatory officer, the contact person for the annual report, dual party invoice, universal service fund, gross receipts, and lifeline for ETCs.
If it's okay, as we go through each change.
Yes, ma'am.
Or amendment, I would like to go through the participants to see if there's any comments regarding the proposal.
Yes, ma'am.
Does anyone have any comments regarding the proposed amendments to 103-612? Is that 612? Yes. Hearing none. Ms. Boyd, you want to continue, please?
Yes, ma'am. We'll continue with Regulation 103-614, interruption of service. Staff proposes to add an additional sentence in this regulation that relates to service outages impacting a significant portion of customers and outages or failures of major company infrastructure lasting more than 24 hours shall be reported to the Commission and a copy provided to the Office of Regulatory Staff.
Will the parenthetical remain in there?
Yes, I didn't want to come across as people not being able to read, Chair. That's the only reason why I didn't read that.
That's fine. I just want to make sure.
Yes, ma'am.
Any comments on the amendment to 103-614? Hearing none. Ms. Boyd?
Okay, thank you, Madam Chair. The next regulation, so 103-621 relates to customer deposits, and as you can see, there are several subsections The section that's impacted under 103-621 is the interest on deposits, 103-621.3. I'm on page 7. And section C, when deposits cease to draw interest, staff proposes adding language that the interest ceases to accrue when notice is sent to the customer's last known address by bill insert, electronically, or by any other method of notice selected by the customer and maintained in the customer's records at the telephone utility.
Okay. Any comments on this amendment? It's going to be 103-621-3C. Commissioners, if we have any comments, we should be making them, or questions we should be asking at this time. Was this recommended in the stakeholder group?
Yes, ma'am.
meeting?
Several of these changes were recommended by interested stakeholders during the workshop.
Thank you.
Yes, ma'am.
Okay. Hearing no questions, please go ahead, Ms. Boyd.
Okay. Next regulation, 103-623 relates to adjustment of bills, and you've seen this one pretty much in Articles 3, 4, 5, and 7. It relates to when a customer is willfully overcharged on the customer's utility bill, and the proposal addresses how interest is assessed. Interest would be assessed pursuant to Code Section 34-31-20A. And that's basically the change here.
And that code section is in the Department of Consumer Affairs section. Is that correct?
34. Chair, I'm not sure that's.
I'm not sure that's.
I'm not
it
sure
either.
that's Department of Consumer Affairs.
I can't remember.
That may be the bank title.
Oh, okay. The legal rate of interest, I think. That's where it is. Thank you. Any comments on this section? Hearing none. Ms. Boyd?
Okay, Chair. Yes, ma'am. I'm coming. I just want to tell you which title this is.
Madam Chair,
Vice Chair Powers?
Johnson,
Yes, sir.
when it talks about the interest on deposits.
Yes, sir.
What's that number? How is that number set?
Okay, so we talked about this issue, Vice Chair. That's the only reason why I think I may know the answer to your question in the workshops. And I have a commission order. I'm going to ask Ms. Purvis to display it, okay? And it's a 2003 order if we're talking about the same thing. So the section I'm referring to in the regulation relates to when a customer is willfully overcharged. Ms. Purvis, would you display this order? It's order number, I think, 2003-593. And it basically says, this was set by the commission, current rate of interest paid on customer deposits. And pursuant to this order, it was 8%, and then they modified it down to 3.5% effective January 1st, 2004. So I think that rate is set by commission order. This other one, though, is a little bit different.
I just know judgments, interest is tied to whatever.
Supreme Court.
Yeah.
Yes, sir.
Okay.
And that's in that same section too. I think it's section B. In the proposed regulation, Commissioner, Vice Chair, Mr. Vice Chair.
Okay. Thank you.
Thank you. And Madam Chair, that is Title 34 is banking, financial institutions, and money. All right. Okay, let's see, next section. All right, Madam Chair, the next section is 103-628. It relates to complaints. And two small changes here. In section C, we're asking that the word regulated the words deregulated be added before the word charges. And so that sentence will read, if approved, the ORS shall promptly and thoroughly investigate complaints concerning deregulated charges, practices, facilities, and then we added an S to the word services of the utility.
Any questions or comments regarding this amendment to 103-628C? Okay, thank you. Ms. Boyd?
Yes, ma'am. Okay, so the next section, Chair, relates to directories. And due to technology and access to consumers, customers' information electronically, changes were recommended, and commission staff thought that they were appropriate relating to directories. Now, you'll notice that if these changes are approved, a customer may still request a copy of a directory from a telephone utility. But the changes provide now the option for the utility to maintain the customer's information, the name, address, and telephone numbers via an electronic database. As I said, the customer directory will be made available to a customer upon request. Other information included, and I can go through, Chair, and read each of these, but the other information, since the production of the directory is basically at the will of is produced at the will of the customer, we deleted sections that would conflict with the requirement that the utility must publish a hard copy of the directory. Let's see, the old section F, now would be, if approved, it would read section C, relates to directory assistance providers, and the new language requires the telephone utility to provide updated information to the directory assistance provider as reasonably necessary, but not normally where the address is different from the address normally associated with an Exchange directory. We deleted that information. Let's see. Would you like to do this paragraph by paragraph, Chair?
I think that we can just do I'm just going to ask if there are any comments on these edits to 103-631 regarding the name is now changing from directories, or proposed to change from directories to directory information. Any comments or questions, Commissioner? Hearing none. Ms. Boyd?
Okay, thank you, Chair. Okay, the next section, 103-652, testing facilities. The word reasonably is added before the word requested. So the reasonable request, of course, will be made by the Office of Regulatory Staff. That is the addition to this 103-652.
Any questions regarding the amendment to 103-652? Hearing none. Ms. Boyd?
103-663, service standards. We are recommending two changes in 103-663.1, availability of service. In Section A, service orders, we added service orders for installations, just added an S at the end of the word installation. And in 103-663.2, equipment requirements, the less than sign is added before 1.5% and 3%.
Any questions regarding these proposed amendments to 103-663.1 and 663.2? Hearing none.
Okay. Chair, if it's okay with you, I will take 680, 681, 682, 683, and 684 together, Chair, only because if it's okay with you, due to the repeal of the statute relating to the Telecommunications Relay Service Advisory Committee, and we're just asking to delete those regulations because of the repeal of South Carolina Code Annotated Section 58-9-2540.
You're just conforming the regulations to
the statute.
To the statute.
Yes,
is that
ma'am.
correct? Any questions regarding amending by striking regs 103-680, 681, 682, 683, 684? Hearing none.
Okay. The next section, Chair, we are 103-690, designation of eligible telecommunications carriers. So the synopsis in the proposed regulation basically states Commission staff is making suggestions to update and include citations to federal law and to delete reference and citations inconsistent with federal law. Some of these changes include, for example, link up service. If you look down in 103-690B, the definition for link up service is deleted as it's no longer a required service for ETCs. Let's move on to, yes, definition for link up. Under C, requirements for initial designation as an eligible telecommunications carrier. So under C, used to be little a, staff is asking to change that to C1. At the bottom of that first paragraph, you'll notice a lot of underlined language. And the first federal citation that we reference is 47, or citations are 47 Code of Federal Regulations, sections 54.201 and 54.202. 54.201 covers definition of eligible telecommunications carriers generally, and then 54.202 covers, 47 CFR 54.202 covers additional requirements for commission designation of eligible telecommunications carriers. Then, Chair, the next sentence begins, in addition, the carrier must commit to provide service throughout its proposed service area. If you compare the language from where I just began reading to the very end of that paragraph, you'll notice it's the same language that's been struck below. So we just moved that language
from
up.
1A.
Yes,
You
ma'am.
just moved it up.
Just moved it up. Yes,
Okay.
ma'am. Okay, so then we deleted language in B, in C, B, let's see, little a, capital B, about information that must be filed with the petition or application for designation as an ETC. And that covers what we struck included a 2-year plan that describes with specificity proposed improvements, how the ETC, prospective ETC will plan to expand its network, a detailed map of coverage area, all the way through number 9.
Okay.
Okay?
Can we take these first two parts?
Yes,
since
ma'am.
it's kind of long.
Yes, ma'am.
I just want to ask, is there any comments or concerns, questions from the participants or the commissioners regarding these first two? They're going to have to conform, the applicant's going to have to conform with the FCC regulations,
Yes, ma'am.
right? And
Chair Belzer,
Commissioner Carolee Williams.
thank you. Would you, Director Boyd, would you give us a little bit more background on why this change is being made?
It's just to so it's my understanding that since these regs were, golly, give me a second. I want to say these regulations were done like in 2006, but let me make sure. We've not amended the regulations since that time related to ETCs to conform with federal law. So that's the reason for the change.
So the reason really is to conform with federal law.
Well, Commissioner Williams, I can say this based on our my interaction with other stakeholders during the workshops. This is staff's interpretation, or this is staff's work product as a result of what it believes will conform the certification process with federal law. The last time that this regulation was added in 2008, and it's not, when I say this regulation, 103-690 was added in May of 2008, and it's not been amended since that time.
So is this information no longer needed, or is it provided in another area?
Okay, so.
That may take us to another
No,
place,
I don't think so.
but- Okay.
So what we did is we referred to the information in the code section that I was reading, the federal code section in C1. So do you see where we begin in the middle of that paragraph? Any common carrier in its application filed with the commission and a copy to ORS. Do you see where it starts underlining? Must
Yes.
provide, okay.
Yes.
That's the next section. We hadn't gotten to that one yet, but
No, I think
No,
you're
we are there.
C1.
C1.
I
And s-
appreciate the attention to that because I was looking farther
Okay.
down.
Yeah. So what I just, this is the federal's, regulation that I was referring to, Commissioner Williams. So that's 54, that's a copy of 5447 Code of Federal Regulations 54.201. And then this is a copy of 54.202. So this is what we now refer to. When I say we, the regulation now refers to federal law. Hopefully the federal regulation numbers will not change. If they don't, then I think the regulation will remain in conformity with federal law. Will be consistent, let me say that, with federal law. The requirements that are pursuant to federal law. So that's what we were trying to do here in this particular section. Does that make sense?
Thank you.
any further comments, questions? Ms. Boyd?
Okay, so now we move to that last, let's see, Chair. Okay, I think we're on page 16 now, because I spoke through number 9 regarding the existing requirements. And then what was formerly capital C relates to carriers seeking ETC designation solely for participation in the Lifeline program. And we struck reference to link up. We clarified that this relates to carriers seeking participation in the Lifeline program but not seeking high-cost support. That these applicants shall provide to the Commission and the ORS the information set out in the 2 federal regulations I just mentioned, 54.201 and 54.202, related to Lifeline only, and that these carriers shall also submit a plan that describes the carrier's advertising and outreach programs for identifying, qualifying, and enrolling eligible participants in the Lifeline program, instead of the language that is below, that appears below that's stricken in numbers 2, 3, 4, 5, 6, 7 below.
Any questions or comments related to the amendments to 103-690 C, CC? C1C, well, I'm not sure where we are now on the numbers. It would now be, it was former AC, anyway. I think y'all are with me on the paragraph. It's now gonna be it will now, I'm on page 16 where the big C is stricken and it's replaced by a numeral 2. Carriers seeking only Lifeline program, and not seeking high-cost support. You with me, Ms. Fox? You were, as I was trying to figure out what number it was, you were looking a little. Okay, just want to make sure. Any questions, comments, concerns? Mr. Mustian?
Could you just give me 1 second? All right, Madam Chair, we're good.
Thank you, Mr. Mustian. Ms. Boyd?
Okay, and Chair, there's one last section on the top of page 17 where we just struck the lowercase b and added the number 3. I don't see any other changes in that paragraph. I thought I would just mention that.
It's just conforming to the new numbering of
Yes,
that
ma'am.
section after amendments?
Yes, ma'am.
Okay.
Yes, ma'am.
Any concerns with the renumbering of that paragraph? Ms. Boyd?
Okay. And then 690.1, 103-690.1 relates to annual reporting requirements for designated eligible telecommunications carriers. So I think I will move through each change, Chair, if that's okay.
That's fine.
Okay. All right. So the first change is in B, capital B, and this relates to filing deadlines. And we struck at the end of the 4th line the date June 30th, 2008, and thereafter annually. Since that date is passed, we just left June 30th of each year. The next change is in the following paragraph. So right under B, little a, there's a full paragraph, and then there's a next paragraph that begins with the word reports.
Yes.
We added the word current before the word cellular, telecommunications, and Internet Association's Consumer Code for Wireless Service, and then struck the date as of May 18, 2008. And then at the bottom of the page, little b, we added that the common carrier designated as an ETC shall provide information to the to the Commission and to the Office of Regulatory Staff. And in lowercase b, number 1 at the bottom of the page, it references a progress report. We struck the phrase or the words "to year," and then struck wire center and added the words "of designation." So the sentence will now read, "The information shall be submitted at the level of designation," since the level of designation could be, the scope could include something other than a wire center. So that I'll stop there, Chair.
Any comments or questions, Mr. D'Antoni?
Madam Chair, we have some comments with regard to 690.1. We have a presentation prepared for that. It may be...
You want to do the whole?
Yeah, it may
The
be
whole-
prudent just to go through 690.1, and then we can address our concerns after that.
Okay. Thank you, sir.
Okay.
I have a question.
Yes, ma'am.
In that B1 at the very bottom of
Yes,
the
ma'am.
page, we're striking 2-year service quality improvement plan in the first line, but we're leaving a forward-looking 2-year plan.
Okay.
Plan annually in the last sentence. Is that correct?
We are, Chair. I don't know if that would have, to make them consistent, though.
I know they're 2 different plans, but
Madam Chair, if I can probably clarify that. The FCC rules currently require a 5-year improvement plan. And with the reference back to whatever the federal requirements are, it's a 5-year plan. So I think that's
Okay.
why the 2-year was struck there.
all right. I understand they're 2 separate plans. I just didn't know the rationale, so thank you very much. Thank you, Ms. Boyd.
Yes, ma'am.
Any other questions regarding this part? We'll keep going and get to the end, and then we'll recognize Mr. D'Antoni and
Yes,
anybody
ma'am.
else.
Okay, Madam Chair, so I'm going to move over to page 18. And paragraph 8, you see it currently reads certification that the carrier acknowledges that the FCC may require it to provide equal access to long-distance carriers. Equal access is no longer a requirement for eligible telecommunications carriers. The next one, number 9. So link up services are no longer a federal requirement of ETC carriers. And so hence the reasons for the stricken language in existing paragraph 9. The number of Lifeline customers that received assistance as of December 31st would be reported under that section, not link up customers. And the survey for the Lifeline verification Copies of responses to the Lifeline Verification Survey or certification filed with USAC will no longer be required to be filed with the Commission and the ORS. Existing paragraph 11 adds the word program after Lifeline, and it deletes the reference to link up programs. And that's it on that page, Chair.
Let's go through the next page, and then I think, since we have comments regarding all of them, instead of breaking it up.
Thank you, Chair. I was just looking at my notes. Okay. So for Section E on page 19, in the caption of Section E, capital E, ETC requirements for Lifeline, reference to link up is deleted. And in capital E, lowercase a, we add a reference to, at the end of that sentence, to 47 CFR Part 54, Subpart E, and that section, 47 CFR Part 54, Subpart E, relates to universal support for low-income consumers. So we're asking the ETCs to file or to comply with the information that is now required by this federal regulation versus what's delineated currently below.
Any questions or comments regarding, we'll take the whole 103-690.1. Mr. D'Antoni, you want to go first? I'm not sure if you'd be first or only. I don't know yet.
Madam Chair, that's fine with me.
Okay. Do you want the?
Yeah, he needs the podium chair.
Okay.
Okay, so you can use this if you want. Do you want to stand here? Whatever your preference is.
We need for you to be at a microphone because we have two commissioners that are virtual.
You can stand here if you want to sit. Okay. And there you go. Move this out your way.
Good morning, Madam Chair, Commissioners. Again, my name is Andrew D'Antoni. I'm here on behalf of the South Carolina Cable Television Association. We just have several comments and concerns with regards to the proposed revisions to 690.1. Just by way of introduction here, are my slides? There they are. Got it. Just by way of introduction, what we're trying to do with our proposed revisions is exactly what Ms. Boyd said, is to more closely align 690.1 with current FCC regulations. As Ms. Boyd alluded to, the current regulations were adopted in about 2008, and it was in response to new FCC requirements, which is why current 690 and 690.1 largely mirror former versions of 47 CFR 54202 and 54209. So the idea behind our proposed revisions are to, again, more closely align 690.1 with the current FCC regulations. So the first thing we want to talk about is the service improvement plan. And on the left of this slide, and you can find these excerpts, they are on page, in case it's difficult to see on the slide, you can find this, the first one, the waterfall there on the left. This is at page 15 of hearing exhibit number 3. And as Ms. Boyd stated, it incorporates in 47 CFR 201 and 202. And at 47 CFR 54202, that has the 5-year service plan. So that's built into 54202. And that makes sense because as we move one step down the waterfall to 103-690C, parenthetical A1B, and that can be found at page 16 of hearing exhibit 3, they struck the 2-year plan. Again, so because we're incorporating 54202 that already has the 5-year plan, the 2-year plan that's there is just unnecessary. So that's been struck, and we agree with that. And then if you follow the waterfall down one more step, and we're now at 690.1 B1, and that's at page 18 of hearing exhibit number 3. You can see also that they struck the 2-year service quality improvement plan. Again, because working back up the waterfall, this is all coming from the 5-year plan at 54.202. So the first revision that we propose, in addition to the revisions Commission and staff has already inserted, is on the right hand of our slide, and is that first bullet. And the way we think it should read in order to better harmonize 690.1 with the FCC regulations is that a progress report on its, and of course 2-year is struck, service quality improvement plan submitted pursuant to 47 CFR 54.202 A1 Roman numeral 2, which is the 5-year plan, that's where it's coming from. It's submitted to that unless that has been waived or otherwise not required by the FCC. And the reason why that's important is that in some funding programs, for instance, RDOF, the FCC has elected to waive the 5-year requirement. And the reason why that is because there's technologies available now, such as the hub portal, that allows them to gauge that build out. So if a carrier or if a communications provider doesn't have that requirement under 54.202 in the first instance, we think that should be also reflected in the annual reporting requirement. So if I don't have the 5-year plan in the first instance, I don't have anything to report on at the annual reporting requirement stage. So again, that submitted, progress report submitted pursuant to 47 CFR 54.202, unless waived or otherwise not required by the FCC, is meant to harmonize that annual reporting requirement with where the FCC stands on the 5-year requirement. As far as our second proposed edit, we believe that the forward-looking 2-year plan should be struck altogether. We're not aware, I don't see that in 54.202. Again, if we're trying to harmonize our regulations as they currently stand with where the FCC is, I'm not aware of a forward-looking 2-year plan requirement under 54.202. And again, the FCC waived the 5-year plan for instance, for RDOF participants for good reason, because there are technologies now that allow them to gauge the build out. So these would be our proposed revisions to 690.1 with regard to the service improvement plan progress report. Our second request is that the annual outage reporting requirement, and this is at 103.690.1.b, parenthetical B2, that the Commission reconsider striking that outage reporting requirement. And the reason is because the FCC has likewise struck and no longer requires that annual outage reporting requirement, and for good reason. And the reason is that the NORS database, the Network Outage Reporting System, which is now available to state agencies like the Commission, already collects that data. So I have just here with me, the NORS user manual, and just to give you an idea of the level of data that's being put into NORS by carriers in the event of an outage, I'll just go over through some of the reporting fields from the user manual. Of course, the company has to list its name, the type of reporting entity, the date and time of the incident. It has to list the duration of the outage, in other words, the total time elapsed. It has to list whether or not it affected a 911 call center. It has to talk about the services that are affected by the outage, the number of users potentially affected by the outage, the geographic area affected by the outage. It has the provider has to provide a description of the incident, and the manual here says to provide a narrative that describes the sequence of events leading to the incidents, the steps taken to try to resolve it once it has occurred, and the actions that finally did resolve it. And that includes the description of the causes, both the direct and the root cause, as well as contributing factors. And then you also have to provide data and information with respect to steps taken to prevent reoccurrence, applicable best practices that can mitigate the outage, and the analysis of those best practices. So again, this is a very thorough data collection tool that the FCC uses to collect this annual outage reporting requirement. That's the reason why carriers no longer have to provide that. That's the reason why it's no longer an FCC requirement. And because this NORS database is now available for states who apply, we believe that likewise the outage reporting requirement currently under 690.1 is just no longer necessary since this data is available. There's no use, there's no need to allow or to require a carrier to essentially do the same thing twice. So we would again respectfully request that the outage reporting requirement be struck. And finally, the unfulfilled service request requirement. This is also another requirement that the FCC has eliminated. And again, for the purpose of harmonizing our state regulations with the FCC regulations, we would likewise, ask the Commission to consider striking the unfulfilled service request requirement here. And again, this has to do with changes in technology. So for instance, I talked about the hub portal. And that stands for the High Cost Universal Broadband Portal. And what that is that's a portal where providers are required to submit data and information showing their actual build out of broadband. And again, I'm kind of looking at the user manual here. Some of the data that's got to be provided, specific longitudinal and latitudinal data where build out has occurred, the data deployment, the speed tier, the specific address and number of locations served at the address. There's also a milestone certification and reporting page in the hub portal that allows users to track the deployment and reporting obligation, including a carrier's total build-out requirement, the number of locations submitted to the hub, and progress towards meeting those build-out milestones. So again, it's a sophisticated data collection tool that provides the Commission with access to the build-out data already that renders the unfulfilled service request requirement unnecessary. That's what the FCC found, and we believe that we hope that the Commission would likewise find that this is no longer a necessary reporting requirement. And the Commission, as we sent a letter on August 29th, 2022, in the companion docket to this docket, 2020-247A, and it provided the Commission with instructions on how to gain access to the hub portal. And we provided an email point of contact, and we'd actually reached out. It's an email point of contact to the Universal Service Administrative Company. That's not a dead email. They're actually responsive. They responded to us, and attached to that letter is a single-page application that the Commission can submit to gain access to the hub portal to all that data showing the build-out, which we believe will render the unfulfilled service request requirement unnecessary. And with that being said, Madam Chair, subject to your questions, that's all I have.
Mr. D'Antoni, I just want to be clear that on that last one that you're referring to as the hub build-out, that is, let's see, 690.1B, capital B, little b, 3. Am I in the right paragraph, what you're referring to as hub build-out?
Yes, Madam Chair, I believe that is correct, yes.
Okay.
And it's not,
So,
and the hub is not, Madam Chair, just to clarify, the hub is a portal.
Is the portal.
Yeah, where
Okay.
carriers have to access and put in their data on their build-out efforts.
So let me just go with me here for a minute. I just want to make sure I've got my notes straight here. You've recommended additional language at the bottom of page 17 in that little B1, and then strike the last sentence. Is that correct?
Yes, Madam Chair, I'm at page 18 of Hearing Exhibit 3. I'm at, as you said, B1. That's the
Okay.
progress report. We
And
would.
then, and then you want to strike number 2 that follows that paragraph.
Yes, we would strike the outage reporting requirement.
And strike number 3 is what you're recommending as well.
Correct. We
Okay.
would strike the requirement for unfulfilled service requests.
I just want to make sure I've got your requests.
Yes, ma'am. And then
Straight.
also just for B1, just out of abundance of caution, again, we were, as far as the progress report annual requirement, we wanted to add language.
To the first line. After,
Yes, ma'am.
after plan, you had additional language.
That it's submitted that plan submitted pursuant to 47 CFR 54202 A1 Roman numeral 2, unless that's waived or otherwise not required by the FCC.
Okay, and then you wanted to strike the last sentence.
Correct. Yeah,
Okay.
beginning with additionally all the way through annually.
Now, my next question is, so that we have all this information, would you like to make your slide presentation a hearing exhibit?
Yes, ma'am. I have copies here for the commissioners, and please forgive me for not handing those out
That's
beforehand.
okay. Any objection to making this presentation that is now part of the verbally a part of the record, a hearing exhibit? Hearing none, we'll mark that as hearing exhibit number 6 and receive it into the evidence of this case.
Thank you, Madam Chair.
Thank you.
Appreciate it.
Well, any further questions?
Madam Chair,
Vice Chair Powers.
maybe it's just curiosity or not really understanding. Your group, does it include these streaming services such as DirecTV now that just, comes through my wireless, or any of the others? Maybe not Netflix but Spectrum. Any of those streaming services, are they part of your organization?
Yeah, so the Cable Association is made up of Spectrum, Charter Communications, Atlantic Broadband, and Comcast Cable.
Okay. So the other services that we get, Netflix, they're not part of or required to be part of your organization?
That's right. So anything outside the contours of the services that those three entities provide, that would not
So
include
all
us.
those apps on my screen are not part of your organization?
That's right. We're not the one
Okay.
cluttering your cell phone, Commissioner.
I just wondered. I did not understand.
Yes,
Thank
sir.
you.
Commissioner Carolee Williams.
Thank you, Chair Belser. Mr. D'Antonio, was this a part of the process discussion that Director Boyd oversaw?
Yes, ma'am. This slideshow we presented here is similar to the one we presented in June of 2022. There were some updates. For instance, at that time, NORS access was forthcoming, but now if you go to the FCC's website, NORS access is now available for state agencies. So there were some modest changes, but this is largely similar to our June 2022 brief.
And this question really is for Director Boyd. Will you respond to this recommendation? I guess I'm trying to understand, and it could be a timing situation, why staff chose not to include it in the recommendations to us. So I welcome any insight on that from either of you.
I think staff looked at we considered some of the other stakeholders' feedback regarding the comments received, Commissioner Williams, and the understanding that I think we wanted to make sure that certain stakeholders who are responsible for oversight and monitoring this information received what they needed to receive. We did ask the question during the workshop about staff accessing the information on the federal website. I'm not sure how we can use it still if it's not filed. I mean, that's part of it. That was part of staff's discussion for us finding information that's not in a docket or that hasn't been filed. We can for publicly available information, but as it relates to publicly available information, but as it relates to the certifications that the commission considers in the fall of every year, I don't know. We didn't talk about a process of how we would use that information related to the annual certifications. And then, as I said, I think another issue for staff was the state-specific information we would receive through what's required in our regulations to make sure that the information that we're asking for is amenable not just to be filed in the docket for others who have oversight of reviewing the information. So without saying specific names, we were weighing the concerns of not just the commission, but other stakeholders and comments from other stakeholders and making sure that all received, that it was fair result. So without being too bland, that's what I'm comfortable with saying at this point. Okay.
And does ORS have a recommendation on this, in this regard?
So, just so I'm clear what I'm responding to, are we talking just about all of his recommendations?
Yes.
First I would say, and Madam Chair, I don't know if it would be appropriate to make it an exhibit, but on July the 10th of 2023, we filed a letter in this docket that attached two prior letters, one that was filed in the 2020-247A docket on June 22nd, 2022, and the second, May 19th, 2021. In both of those letters, and I believe in the workshops as well, we have opposed those changes. With respect to the...
I'm sorry, when you
yes.
say propose those changes,
the
same one-
changes that the Cable Television Association is proposing
Okay.
today. They
I just
also
wanna
have
make sure.
proposed these in a prior,
okay.
in prior workshops and forums. With respect to the changes on the updated forward 2-year plan, we believe that that is still an important requirement in the regulation. While I understand that the FCC may require certain things, I think as Mr. D'Antoni mentioned, they can waive that, and I believe that it would be important to continue to maintain that in the regulation in the event that occurred. I also think that ETCs can request a waiver of that when they file their application, but I think it would be important to have that for us to be able to have a forward-looking what the ETC is planning to do in the coming 2 years, as well as with the progress report, which we see as more backward-looking. So we think it's important to maintain that language, that last sentence in 690.1B1. With regard to the outage reports, so I understand his reference to Norse. As Ms. Boyd alluded to, I do have some concern with the, I'm not sure the propriety of the commission staff going out and identifying information that could potentially be coming before them. I'm not exactly sure how that would work. In addition, to the extent that the burden would be put on ORS, that would require us to, proactively on a daily, maybe multiple times a day, to go and look to see what the outage information is. Currently, what we have is, under the current regulation, is the companies, when they submit their information to Norse, they provide us basically just a copy of that and send it to us in a PDF form. So that way we're able to, have, knowledge of when these outages occur without having to go out and actively look for that information. So we think that's important. Don't see that that's a regulatory burden when they file it. Basically, they just PDF the report of what they filed with Norse and they email it to us. I don't see the problem with that. With respect to the unfulfilled service requests, similarly, basically this is a one-page form, and it asks for the simple number by quarter of the number of commitments that have been fulfilled and the new service applications that have been held for over 30 days. We're not talking about a 100-page report. We're talking about a one-page that allows us to see how the ETCs are performing. Are there issues that we need to delve further into? But it's essentially a very brief and simple form that they provide. So we don't really see where these changes are necessary or would, or the existing regulations require any substantial undue burden on the carriers at this time.
Madam Chair, we just see these as unnecessary, redundant reporting requirements. All the data and information is being placed in NORS. The data and information is being placed into the hub. This is the reason why the FCC struck these reporting requirements. And as we mentioned before, that the point of 690 and 690.1 from the beginning was to be in harmony with the FCC regulations. And instead, now what we're starting to create now is this kind of two-tiered system. And maybe that's okay for a provider that's solely located in South Carolina, but the Cable Television Association includes members that are in multiple jurisdictions, and that can become very burdensome. So it may seem like a small burden when you look at it through kind of the straw of South Carolina, but for a member from our association that is providing services in multiple jurisdictions, when you have a patchwork quilt of different jurisdictions, having different requirements, that becomes much more burdensome than just having, a single piece of paper, as Mr. Muschin described, being submitted here in South Carolina.
Well, I think to the extent that we're talking about changing a regulation that would apply to the Cable Television Association, but it also would apply to everyone else. So if you do have that entity that may not be making these reporting requirements to the FCC or falling under the same jurisdiction, the Cable Television Association's changes would apply to everybody and undo that for everybody. Whereas this is a uniform requirement that's clear. To the extent they are able to ask for a waiver of that requirement, they are certainly free to do so. The Commission can certainly grant that. So I just don't agree that this is something that should be changed. We find that this information is important to us in our regulatory role and in our analysis of these carriers.
We appreciate that point of view, but again, when these regulations were adopted in 2008, they largely mirrored the federal requirements. All we're doing is just keeping that mirroring between the federal requirements and the state requirements the same as it was. They diverged over time, which is why we're back here revising these requirements to harmonize more with the FCC requirements.
Okay. Thank you. Commissioner Williams, do you have further questions?
No, I'm good. Thank you very much.
Commissioner
Everybody.
Justin Williams.
Thank you, Madam Chair. Ms. Fox, do you have anything to say on this?
I would like to be heard briefly, but I'm fine to defer until after your
Oh,
question.
no, I want to make sure I hear from everyone before I make any comments or ask any questions. Thank you.
Okay. Yes, on behalf of the coalition, I think it's important to keep in mind that Regulation 690 is for an initial designation of an ETC, and we do agree, and I think everybody agrees, those should be consistent with the federal reg. When you're talking about 690.1, that's the annual reporting by ETCs, and this commission is tasked with certifying ETCs annually to the FCC and saying that they are abiding by their obligations that they've undertaken. And ORS's role in that is to receive these reports, review these reports, and make sure that they're recommending to the commission which ETCs are living up to their obligation. So from the coalition's standpoint, we do defer somewhat to ORS, and we agree. And there's been some talk about unfulfilled service requests. That goes to the heart of what it is, what it means to be an ETC. And our folks have no problem reporting because you have an obligation to provide service to everyone who makes a reasonable request for service within your designated ETC area. And ORS absolutely should know if there's an issue with, all of a sudden you're seeing a lot of unfulfilled service requests. So we have no issue with keeping the draft as the staff has proposed it, and just wanted to make that point. Thank you.
Commissioner Williams.
Thank you, Madam Chair. Thank you, Ms. Fox and Mr. D'Antoni and Mr. Muschin. What I'm trying to understand is the information that ORS receives now in the current form and how that would change under the proposed amendments by Mr. D'Antoni. I'm trying to understand whether or not the information is accessible at all, or is the position is less accessible or harder to access without it being filed in the current form?
Commissioner Williams, I'm not quite sure I understand the question. If the question is under their proposal, then I think the burden would then be on ORS to go out and find that information with respect to the Norse information.
So let's, if you don't mind me
Sure.
interrupting you, let's just explore that a little bit. When you say the burden to go out and find it, when I hear that in my mind, what I'm thinking about is maybe like a treasure hunt or something. Is it not a database available where you can go and just search for the information?
Well,
That's what I'm assuming Norse is.
So I don't know because we have not accessed that database. There is, as I understand it, there is a significant amount of information that's on that database, a lot of which would be, irrelevant to us and the work that we do. But so let's say that carrier ABC has an outage and they report it to Norse. Well, we're not going to know about that unless we have access to Norse. We go and access that. We, go and look through all the carriers, see maybe what's been filed that day, what hasn't been filed that day. We would have to go out and search that information out, as opposed to what currently happens is when a carrier submits a form to Norse and they have a report that's kicked out that says, okay, here's the summary report, and they email that to us. So therefore, we're getting that information directly as opposed to indirectly having to go and look for it on the website, on the Norse database, if that makes sense. So it would be equivalent to, instead of a party having to serve somebody with a pleading or a motion, it would be incumbent upon me to go on DMS every day and to go and look to see what may have been filed or not been filed. So to me, it's really kind of a service issue of they let us know that this outage has occurred. We have that information. If we need to follow up on that, we can. The alternative would be that we would go and look on a daily basis, twice a day, whatever that may be, to try to see, is there something that has occurred? And I mean, as a regulated entity, I understand regulatory burden, but I think that there are some things that as a regulated entity, when you get those benefits that are associated with, with providing service, there is some level of burden of informing the regulator of that information. And I think simply forwarding a PDF of what they filed is pretty minimal.
Commissioner Williams, if I may, this is an annual reporting requirement. I don't know why they would be needing to check every day. They wouldn't get this. This is an annual reporting requirement under 690.1. So I don't know why ORS would feel the need to check every single day to see whether an outage occurred. That wouldn't happen now. Yes. So the reports coming in once a year, with regard to 690.1 A, B, 2. So again, I'm not sure why they would need to check every day when they're getting an annual report now.
So under your proposals, just taking his concerns for what they are, how would ORS receive the outage information?
Well, based on our study of the user manual, and to be fair, I can't, as a private attorney, gain access to NORS, so I haven't gone in there and explored how it works, but we have reviewed the user manual, and as I understand it, it's like any other database you would access. You would develop your own username and password. You'd be able to log in. You'd be able to search through filtering to determine what reports have been filed and where and by whom. That's my understanding as to how it would work. But again, I can't have access to be able to kind of play around to see precisely how. But judging from the user manual, that's how it would work, and that would be available to ORS.
And so, I know you may not agree with ORS's position, but do you see their level of concern is somewhat reasonable in that under your proposal, they would have to go out, someone somewhere would have to build that user profile and retrieve that information compared to the standard status quo, your organization and others file that information with the Office of Regulatory Staff, if I'm understanding the current status quo correctly.
Yeah, this is an annual, reporting requirement, but I don't think there would be much of a burden, at least as far as I can tell, examining the user manual to make the application, for access to NORS. And in fact, I would presume that would be very beneficial. That would be something that the Commission and ORS would want to do, to have access to a database of this type with this level of data.
Thank you, Mr. Mustian. Madam Chair, that's all I have. Thank you.
Thank you.
Madam Chair,
Vice Chair Powers?
just one more thing. Mr. Mustian, the question's gonna be to you, but the comment is, when somebody tells me I need another username and a password, I wanna cry. But, do you get many individual complaints about outages with cable and that sort of thing, from customers?
Not that I'm aware of. I mean, typically when we get something like that, it's when there's some significant outage. So, for instance, a few years ago, there was a pretty significant issue where there was an outage for 30 days, and so that obviously was kind of an issue. I don't know that we get many outage reports from individual consumers on that.
I'm kind of wondering, you talked about having to check it every day or twice a day or whatever. Unless there's some complaint or some known problem, what would be the purpose of checking it every day?
Well, if the point is for us to be tracking service degradation and to see if there is an issue. So currently the way it works is, if there is an outage over 24 hours, is it 30 minutes in duration? Anyway, whatever it is. If that occurs, then, the carrier, once they file that information, we get it. And so we're aware of it. So as opposed to whether it's annual or monthly or quarterly or whatever it may be, I mean, what that's going to require us to do is to go in. First of all, we've got to apparently learn some sort of user manual that I don't know what that is. Second of all, then we're going to have to filter it through. We're going to have to go and search for that and identify, all the carriers, what has happened. And I just don't understand why this is such a significant issue when currently we basically get a PDF of what they've already filed, and it's just emailed to us.
And when you find an outage of 24 hours, what does ORS do?
Mr. Vaughn can keep me straight, but I believe he usually reaches out to the carrier, finds out what has occurred. So what recently comes to mind, I don't think this was an ETC, but maybe it was.
Find out why.
Find out why, what has occurred, what steps they're taking to remedy the service, and then he follows up with them to see, has that taken place? Have they made that, and what's the status of it? And if we see, kind of routine issues, then we can kind of take it to the next level and say, okay, we need to get with you and figure out, what's your plan, what's your improvement so that we can avoid these issues in the future. Okay. So if we're waiting until, the end of the year to find this out, and we have to go and do the search and then track them down, well, by that point, I mean, it may have been several months that this issue has been going on that we could have addressed earlier on in a much easier fashion.
That's a good answer. Thank you.
Mr. Mustian, I just want to be clear on something. These reports, they're not related to cable TV. They're related to the telecom portion. Is that right?
Correct.
Okay.
Yes, ma'am.
All right. Just want to be clear on that.
Yes, I don't want to get cable television
I don't either.
complaints.
Commissioner Caston?
Yes, ma'am. Thank you, Madam Chair. And Mr. D'Antoni, I don't think there's any desire to increase any regulatory burden on me, and certainly not mine. but you do understand that different states operate under different regulations, different laws. You know, we're very much restricted under ex parte rules and such as that. You understand that part.
Mr. D'Antoni, he was addressing that to you.
Yeah,
Oh, I'm sorry. Yeah.
Okay. You use the mic, please, so that he can hear you. It's
Forgive
on.
me, Commissioner Cass, and I didn't catch the end of your question, sir.
It's because it didn't come out. I'm sorry. You do understand that, you know, different states have different requirements, regulations, laws, and ex parte restrictions and such as that. If one size does not fit all in every state, if as the cable companies, as your organization as deals in multiple states, you understand that, correct?
Yes, sir. If I understand the question, the question is that, you know, there are a variety of different reporting requirements across jurisdictions. Have I understood you correctly, Commissioner?
Yeah, yes, sir. And the point being is, I think Mr. Mustin talked about understanding the regulatory burden and goodness, I don't think there's anyone desiring to increase the burden on anyone unnecessarily, but you do at least acknowledge that, you know, there may be different requirements in this state versus another state that you serve.
Yes, sir. We certainly understand that, and just, you know, again, I can't emphasize enough. This is the annual reporting requirement for an ETC. There's already a regulation 103-614 about an interruption of service, where you have to provide notice, you know, more immediately. This is the annual reporting requirement under, you know, 103-690.1, and what we're saying is that that data is already available and inputted into NORS, and you can check annually to find that data. You know, I understand Mr. Mushin's concern about, you know, we don't want to be thrust into a position where, you know, we have to check daily to find if something has occurred. That should be pushed to us. But I'm looking at 103-614, interruption of service, and it says the utility shall report any information required to be reported to the FCC regarding outages to the commission and provide a copy electronically to ORS. So again, there's already a regulation that deals with the more immediate report. What we're talking about is the annual reporting requirement of an ETC under 103-690.1. I don't want those to be confused.
Excuse me, may I be heard on that?
Ms. Fox?
The regulation that Mr. D'Antoni is referring to applies to telephone utilities, but not to cable companies. So the real-time reporting of outages does not apply to his companies. It applies to our companies, and we have to do that. What this is dealing with is at least once a year. If you're going to be an ETC in South Carolina and undertake that obligation to provide service under those terms and conditions, should you be required to give ORS an annual report of all the outages you had that year so they can determine whether or not the ETC has properly met that obligation. So I didn't want there to be confusion about the regulation 103-614. That applies only to telephone utilities, but you know, certainly our companies do that, the real-time reporting, and don't have a problem with the annual reporting.
And we appreciate that clarification, but again, what it's showing is that this is again, what we're emphasizing here is this is an annual report, and that, you know, if you want to access, you know, what's occurred over the last year, you can go to NORS and access the database at that time. You know, again, we're trying to reduce the regulatory burden and to harmonize 690.1 with the FCC regulations. The FCC has already eliminated this requirement.
And Commissioner Caston, just briefly, I think it's important to point out we're not adding any regulatory burden This is what they already do. So this is just maintaining what is currently in the regulation.
Thank you, Mr. Muschamp, because that's exactly what I was getting ready to ask you. And that one-page form you showed again, just for my edification, when is that form submitted?
So there were two forms that I referenced. So there's one, the quarterly service quality report. So that's related to the unfulfilled service requests. So that's submitted once each quarter. And then, so to the extent that you're talking about the outages, so that essentially we receive those along with or shortly after the carriers have provided the information to the FCC database. So I think, for instance, the one I'm looking at, an outage occurred on January the 10th, and we received it, a couple of weeks later. So I think it just typically depends on when they report it, but it's pretty much as soon as they send it to the FCC database.
All right. Thank you very much. Thank you, Mr. D'Antoni and Mr. Muschamp.
Madam Chair,
Commissioner Justin Williams.
I got a question I want to make sure I understand you all. Ms. Fox mentioned that the annual reporting requirement or the outage requirement is only for telecom and not for ETC.
The regulation 103-614 that requires the regular reporting of outages as they occur only applies to telephone utilities.
Okay.
Currently, the annual reporting of all your outages you had for that year applies to all ETCs.
Okay. And Mr. Muschamp and ORS, when you all receive the annual report, what do you do with it?
I mean, we do a normal review. I think the same situation would occur. We would look to see, are there trends, or there service degradation issues, those types of things. If it's something that we've been getting regular updates on, then we've probably already been in contact with the carriers. But I mean, if we look at it to see if there's a problem, and I think to Ms. Fox's point, these are ETCs and they're receiving lifeline funding and have agreed to provide service to these underserved communities. And so to ensure that, they're getting this funding from Lifeline, are they using it to provide adequate service?
Understood there. I just want to make sure that it's not as if the report that comes to you all, the annual report, is coming in a time-sensitive manner. It just comes annually, and once you receive it, whatever review you deem appropriate, you conduct at that time.
Yes, I mean, I think we're getting a field from kind of what the issue is. Yes, we get them April 1st.
The ETC annual report is on June 30th every year.
Okay.
So, but I mean, I think this is getting away from the ultimate point of, do they submit to us an annual report, or do we have to go out and locate it on NORS? I mean, that to me is what the key part of this is.
Right. I agree with you, sir. I'm trying to see both sides of the issue. So under Mr. D'Antoni's proposal, it seems to me ORS, say on June 30th or whenever they decided they wanted to go out to look at NORS, could go and pull those reports, hypothetically, of course, and conduct the same level of review similar to the reports being emailed or sent in some way, shape, or form to our ORS, and the same level of review is conducted.
I mean, in theory, yes.
Okay.
In theory, yes. But I mean, I think it's then putting the burden on the regulator to go out and identify that information. And I just don't think in a regulatory structure that that's the way it should work.
I understand. Thank you, sir. Thank you, Madam Chair.
May I? Mr. D'Antoni, you indicated 3 ETCs that are part of the South Carolina Cable Television Association?
As far, as far as,
ETC.
yeah, no, so as far as Comcast and broadband, I don't know whether or not they have an operating entity that may be an ETC, so I don't want to say anything I don't
Okay.
know. As far as Charter Communications, not Charter Communications itself, but it has operating entities, that have been approved as your.
So Charter may have more than one ETC, is what you're telling me? I'm talking about in South Carolina.
Yeah, we filed a joint application for ETC status for the RDOF award for.
Right.
some of
So
Charter's
how
operating
many ETCs are you here speaking on behalf of today?
To my knowledge, it would be those two.
Okay. And how many ETCs are approved in the state? So you're here asking about two, and ORS would have to go out and look for how many reports for all ETCs that receive.
I don't know the number. Of
Okay,
total
but it's more than
ETCs in
two.
the state.
It's more than two, right?
Yes, Madam Chair.
Okay.
Yeah, there are more than two, certainly.
Okay, thank you. Commissioner Carolee Williams?
Thank you, Chair Belzer. It's getting harder to remember, but I know Director Boyd mentioned this, and I think that Mr. Mustin mentioned a question about the ability to receive this information in the docket. And it was more of a question as to how appropriate it would be. Can anybody fill in the gaps for me on that?
No, I think it was like staff, if the commission's going to issue an order, going to Google and searching something and then somehow making it a part of the docket. That was just one aspect of our review, our thinking of what's fair here,
Right.
which is why what we proposed. We did we did learn through the workshops. Mr. D'Antoni, Mr. Willoughby talked about the NORS database, and we thought through that. And so, from staff's perspective, would the parties in that docket, would they appreciate, and could staff ethically go and look for information that wasn't filed by a party, but could result in a decision by the commission, if that makes sense. So so we were thinking, and maybe we did take the conservative approach in the proposed regulation. But that was part of our concern. Yes, ma'am.
In that scenario, would ORS file that information? And would that be more appropriate?
I mean, I think that's how it would be. If it rose to the level that we needed to bring it forward for commission action, then that's what we would file. And again, I think what Ms. Boyd said is I don't think it's necessarily going into the docket. I think the concern would be more about, commission staff doing an investigation on their own and how that would comport with the ex parte provisions and that sort of thing. So, I mean, if there is something that gives us concern that we're not able to resolve, then we would bring it to the commission and ask for y'all's guidance on that.
Okay. Thank you. No further questions.
Anything further on this portion of the suggested changes? Ms. Boyd?
Chair Belzer?
Quick question. I'm sorry, does anyone know how many ETCs there are?
15-ish. 10 to 15. Does that sound? No?
There's more than that.
There are a number of ETCs that are designated for Lifeline.
Get the
only.
mic. You're hard to hear. If you could.
Sorry.
That's
There are
all.
a number of ETCs that have designation only for Lifeline purposes or only for wireless Lifeline purposes. There's a bunch of those, but I'm guessing 30, 40 total.
Thank you, Madam Chair.
Thank you. Ms. Boyd?
Chair Belzer, I think that concludes the end of the proposed regulations.
Okay.
With 690.1.
Any of the participants have anything further they want to add to what we've discussed this morning without being repetitious? Okay. I would like to note that as we are conducting this proceeding under the Administrative Procedures Act rulemaking provisions, that the commission will allow written material to be submitted following the hearing for 5 working days after this hearing ends. And If there's anything further that anyone wants to submit, that will, under the rulemaking provision of 1-23-111B, those will be able to be considered by the commission in the rulemaking.
Madam Chair, she's just distributing Mr. D'Antoni's
Okay.
slide.
And I don't know if we gave that a number, but that will be hearing exhibit number 6. Just to make sure everybody has that. And if there are nothing further to come before the commission this morning, going once, going twice, we will close this proceeding and take this matter up at a future commission business meeting. Thank you very much. We are adjourned.